Hello and welcome to this video on private nuisance. This will focus on the theory of private nuisance. There will be another video on how to apply the law to a particular scenario. So the aims of this video will be to describe the rules of private nuisance, identify some supporting legal authority, and of course in a separate video apply the law to scenario-based questions. And in the second half of the video, we will be looking to explain the defences to a private nuisance, explain the remedies for those affected by private nuisance, and of course describe the relationship between nuisance and fault. To begin, we need to consider when nuisance occurs or why people might claim under the tort of private nuisance. So usually this dispute will involve defendants who live in close proximity to each other, but of course it might not be somebody who lives, it might be somebody who owns a business, for example, as well. And the nature of these disputes concern competing claims. Now normally you could do what you like on your own land, but if this activity affects your neighbour's ability to enjoy their land, then there might be scope for a claim. Now, the claim will only be successful if it is unreasonable interference, and that will be the crux of what we discuss in this video. So to define private nuisance then, it has been defined as an unlawful indirect interference with a person's use or enjoyment of land coming from a neighbouring land. And there are two main types of nuisance. So it could be loss of amenity, which you will have covered in other areas of the law. This is essentially loss of enjoyment. So for example, this is nuisance caused by noise, smell or smoke. This would obviously impact on your ability to enjoy your land. But we could also have material damage nuisance when a dangerous state of affairs on the defendant's land cause significant physical damage to the claimant's land, such as tree roots causing subsidence in the land. But we can also see examples of where fireworks would cause physical damage as well. It might then be easier to claim for material damage because this is always claimable, something which we're going to discuss in this video. So the outline then, and this should form any basis of any application as well, is we need to consider the following. We need to consider who the claimant is. We also need then to consider who the defendant is in any given scenario. And then what is the interference, and is the interference unlawful? So they're the two key elements, the interference and unlawful, are where most of this discussion is going to be based. And then we need also to discuss defences and any potential remedies. Now defences are applicable only to private nuisance and Rylands and Fletcher, for example, but others are more general, and you will have come across those already. So we will begin with who the claimant is. So we need to establish in any application of this who the claimant is. So the claimant then is anyone who uses or enjoys land is able to make a claim. But they must have an interest in the land, so that means they must be an owner or a tenant. What this means is they can't be somebody who is related to the owner or partner to the owner, for example. They have to be named on the lease, or they have to physically own the land. So the key case to discuss this is Hunter and Canary Wharf. Now this case will come up again later on, but the claimants here, there were multiple claimants, and they claimed for interference with TV signals when a tall tower building was constructed in the Canary Wharf area of London. Now the Court of Appeal suggested that only owners and tenants could claim for the interference, i.e. not the partners and so on. So this is your authority in with respect to who can claim. So we need to consider who the defendant is also. Next, we need to consider defendants to a claim. Now this normally is the person who is causing, either negligently or deliberately, or allowing a nuisance to occur if they have knowledge of it and fail to prevent it from happening. Now the cases are going to follow this particular section of the video, so Tetlin Chitty is your authority there. Now where the occupier is not responsible, he may even have adopted a nuisance by failing to deal with the problem, even if it was caused by a previous owner or indeed a trespasser. If he has knowledge of it, then they need to guard against it. A defendant can also be liable where the nuisance is as the result of natural causes, but the defendant fails to deal with it. So we're going to see a lot of obligation to protect other people's land in discussion of the following cases. And of course, landlords can be liable for nuisances caused by their tenants. So in Tetley and Chitty, a local authority who allowed a go-kart racing on its land was held liable for nuisance, even though the land had been leased for that exact purpose. Now the local authority was liable because they knew the lease would create a nuisance, so they allowed it to happen. In Sedley, Denfield and O'Callaghan, the defendants occupied land where there was a ditch. Now the local authority, without knowledge of the defendants, laid a pipe to take water away from the ditch. Now the pipe had a grate to stop leaves blocking it, but the grate was situated in the wrong place and became blocked. As a result, the neighbouring land became flooded. By this time the defendants knew of the pipe. Now the defendants were liable in nuisance as the House of Lords decided an occupier who knows of a danger and allows it to continue is liable, even if he or she has not created the danger him or herself. So there is a point here of knowledge. If there's knowledge of it, we need to guard against the thing happening. In Leakey and National Trust, the defendants owned land on which was a large natural mound on a hillside. Now they were aware that it could slip, and following a hot summer it did slip and it damaged the claimant's cottage. Now the defendants were held liable as they knew the slippage might happen and they failed to prevent it. So again, knowledge of the possible danger and failure to do anything about it. In Anthony and Nicole Authority, again illustrating this same point, the defendant took over responsibility for the land from a former colliery, so it's a coal mine. The land was later landscaped and sold as common land. Now a fire started through spontaneous combustion which lasted 3 years, causing fume and smoke interference to people living in that area. The defendant was liable because it was aware of the problem while the tip was still under its control and failed to prevent the nuisance. So what we can glean from that then is a defendant who caused nuisance doesn't have to be an interest in the land from which a nuisance is coming. So it can be a visitor, but it can also be a trespasser, it can be a tenant also. Now the idea that someone who doesn't have an interest in land cannot claim though is unfair, arguably, because people's work or life schedules are more flexible than they once were. So for example in Hunter and Canary Wharf, people were unable to claim. Now under Article 8 of the European Convention on Human Rights, the right to respect his or her family life, private loan or correspondence could possibly be a basis from which to say you have an interest in the land when making a claim. If you look at McKenna and British Aluminium, there were over 30 claimants, including some children, who had no interest in the land affected, but they were able to claim a nuisance for the noise and fumes that came from the defendant's factory. So we see a more recent case there, where people who didn't have an interest in the land were able to claim, so perhaps it would shift now. So the crux of this is going to deal with two things: what the interference is, and then whether this interference is unlawful. So we're just going to look at what an interference is with respect to nuisance. So it does need to be indirect interference. If it is direct interference, then of course that could be potentially another area of law, like trespass for example. If there's damage caused, then it could be negligence also. And indeed it could be Rylands and Fletcher tort, which is sort of an extension of nuisance. But for this we're going to focus primarily on indirect interference. So something happened on somebody's land which then causes some form of damage or loss of amenity to someone else's land or someone else. So we have some examples of loss of amenity then. Fumes drifting over a neighbouring land, or smell from farm animals. So in this case it was a large amount of pigs in Wheeler and JJ Saunders. Or indeed it could be noise from a playground, gunfire, speedway, motor racing circuit, as illustrated in the Kennaway and Thompson. This could also be sports grounds for example. Now some examples of physical or material damage, then we have flooding, vibrations from industrial machinery, which as you could imagine can get a bit annoying, hot air rising into other premises, oily smuts from chimneys, fire, and cricket balls being hit into a garden. So all of these things have been considered to be nuisance in the past. Now, some examples which can definitely not be claimed for, according to case law: protecting a view of surrounding countryside. So if somebody erects property and has permission to erect property which damages your view to countryside from your home, for example, you cannot claim for this. The same is applicable for right to light. There essentially is no right to light, and so we wouldn't be able to claim for this. And as we've seen already in Hunter and Canary Wharf, interference to television reception. Now there is an argument this would change, for example, if this was to be internet connection, for example, given how important it is for most people in their homes, particularly after the last few years when people have begun to work from home, or a larger amount of people have anyway. And as mentioned on the previous slide, Hunter and Canary Wharf, the claimant was unable to claim for the loss of TV reception, and this was actually partly because other forms of reception such as cable and satellite were available. Indeed, internet reception now, streaming, will be applicable, so perhaps this would not be the case anymore. Now, the courts are willing to protect those feelings of emotional distress. Now, this issues are sensitive. For example, in Thompson, Schwab and Kostaki, a claim was successful against the running of a brothel in a respectable London street. So there was an injunction for that to stop. And in Lawns and Florin Place Limited, an injunction was awarded as a sex shop was opened in a street which was partially commercial and social, so there were restaurants and businesses and shops, and it was partly residential also, so it didn't really fit in with the overall area. So they will protect emotional distress. So moving on, arguably the most important is there can be many interferences, but there will only be a successful claim if the interference is unlawful. Now what this means is essentially unreasonable. So the word unlawful is probably misleading, but unreasonable is what we really mean. It doesn't mean actually legal, so doing illegal acts, for example crimes. But the courts try to balance conflicting interests of the neighbours in a nuisance action. But some give and take is expected from both parties. So if one's being unreasonable, then of course we will have a successful claim. So what the court does then is assesses whether interference was unreasonable or excessive. So some nuisance might not be successful. So some fault will usually be involved, but it doesn't need to be proven. The thing itself, the nuisance, needs to be proven only. And the way the court will look to see whether the interference is unlawful is by looking at these factors on the screen at the moment. So the first one is locality. The second is duration of the interference. How long has it been going on? The degree of interference. To what extent has it been interfering with the claimant? The sensitivity of the claimant, and the idea that the more sensitive the claimant is, or the more sensitive the activity is, then less likely to be a claim. We also need to consider malice. So if it's being deliberately malicious, then there's more likely to be a successful claim. And then the social benefit. So the social benefit may override the nuisance and consider the claim to be unsuccessful. So we'll deal with each of these in turn. We'll look at particular cases which are looking to explain those elements too. And we'll start with locality. So what we need to consider here, and you need to consider in your scenarios, is what is the character of the neighbourhood? Okay, because we can expect certain things to happen in certain areas. So for example, a residential area may be relatively quiet. A partly residential and partly industrial area may be slightly more loud, maybe more interferences, and that might be perfectly acceptable in that type. Now we could consider, is it a town where it's likely to be more quiet, or is it a city where it's more likely to be more busy? But we also need to consider, has the character of the neighbourhood changed over time? So if it began as a residential, but then more and more businesses were moving into that particular part of town, then it may be considered partly industrial, and then certain things may be expected and may not constitute a nuisance. So Lord Justice Thesiger in Sturgis and Bridgman came with the famous quote, what would be a nuisance in Belgrave Square, which is pictured, would not necessarily be so in Bermondsey. Okay, so what would be a nuisance in one place may not be in another, and that needs to be considered. However, there's one kind of disclaimer here. If the nuisance creates physical damage, then the location is completely irrelevant. So a case to illustrate this last point is Halcyon Esso Petroleum. The defendant owned an oil depot located in the middle of a housing estate. Now, as tankers were coming at all hours, this was affecting the sleep of the resident. Now, this was considered a nuisance. In Heroes Electricals and Peak Ingredients, the defendant manufactured ingredients for curries in an industrial estate, but this was close to the claimant's business. Now, the claimant complained about the smells coming from the defendant's premises, but as it was an industrial estate, the claim was unsuccessful. You expect things to occur in that particular environment. In St. Helens Smelting Company and Tipping, there was damage caused by smelting to crops, trees and foliage. Now, the location was irrelevant as physical damage was caused, so this claim was successful because it was physical damage. Now, in terms of duration of the interference, what we need to consider is how long has the interference been going on. In essence, the more it's been continuing, the longer it's been going on, the more likely the thing is to be considered a nuisance. So to be actionable then, interference is likely to be continuous and is carried out at unreasonable hours of the day. So make sure you look out for this in your scenarios. Now, the difference between a one-off or late night noisy party and regular parties then is clear. It's night and day. The one-off late night noisy party is not going to be a nuisance, but if a person does it consistently, then it will be. Now, however, in one case, an event lasting for a maximum of 20 minutes was held to be nuisance. This was fireworks, but because it did indeed cause physical damage as well, which we're going to look at in a moment. And usually though, it cannot be a temporary nuisance. So just some cases to illustrate this. Crown River Cruises and Kimbolton fireworks. The defendant's firework display lasted 20 minutes, but the debris started fires on the claimant's boats. Now, because there was physical damage, it was considered to be nuisance even though it only lasted for 20 minutes. In De Keyser's Royal Hotel and Spicer Brothers, the building where it occurred at night and was held to be unreasonable as it interfered with the claimant's sleep. So of course, unreasonable because it's at night. That's just what we expect from these cases. When we consider the degree of interference, the greater the interference is, the greater the chance of a successful claim. Now, physical damage is always actionable, but if the claim is a loss of enjoyment, then material interference must be proven, so it needs to be substantial. If you look, for example, at Murdoch and Glacier Metal, the claim was unsuccessful and the claimant claimed he lost sleep because of a constant low-level droning from a defendant's factory. Now, the claim was unsuccessful because he was also near a busy road and this didn't interfere with ordinary existence. No one else had complained, so it was him being sort of unusually sensitive, if you like, and therefore it wasn't material interference. In terms of the sensitivity of the claimant, if the claimant is deemed to be particularly sensitive, then the action may not be successful. Now, the interference must affect ordinary use of the claimant's land. So when we consider Robinson and Kilvert, the defendant's business of making paper boxes required a warm, dry atmosphere. Now, he let out the ground floor of the premises to the claimant, who used it to store brown paper. Now, because the place above was so warm, the heat generated from this work damaged the brown paper that the claimant stored. Now, the defendant was not liable as the claimant was unusually sensitive. Now, what we mean is this wouldn't affect ordinary people, and so he couldn't claim he was more sensitive. Now, in McKinnon and Walker, this illustrates the point a little differently. So the gas leaked from the defendant's factory and damaged the claimant's sensitive plants. Now, the reason, although these plants were sensitive, the claim was allowed as the gas would have affected ordinary plants as well. so the claim was successful. In terms of network, rail, infrastructure and Morris, the law on nuisance is moving away from this abnormal sensitivity to a general test of foreseeability. So this is our more modern test. Now the claimant ran a recording studio near the London to Brighton rail line. Now the railway company installed a new track circuit which interfered with the amplification of electric guitars, causing the claimant to lose business. Now the Court of Appeal considered that the use of amplified electric guitars was abnormally sensitive equipment and the interference was not foreseeable, and therefore the defendants were not liable. Now if there is particular malice, this would need to be considered. So a deliberately harmful act would normally be considered unreasonable behaviour and will be considered a nuisance. So the more malicious the defendant is, the more likely it is to be nuisance. So consider Hollywood Silver Fox Farm and Emmett. The claimant was bred mink on his farm. Now the defendant had a disagreement with the claimant and told his son to shoot guns near the property to frighten the animals so they wouldn't breed. Now this was deliberate and unreasonable act and amounted to a nuisance, okay, because it was malicious, so it was held to be nuisance. In Christie and Davy, the claimant was a music teacher and he held musical parties and lessons in his house. Now be careful with this case, the person playing the music was not the defendant in this case. The defendant was the next door neighbour who became annoyed by the noise, and he responded by banging on the walls with hands and with trays and blowing whistles and shouting to ensure the music parties and lessons were disturbed, and that was the nuisance. So there was an injunction was granted here against him due to his deliberate and malicious behaviour. We also then need to consider social benefit. Now, if the defendant is providing a benefit to the community, then the action for nuisance will usually be considered reasonable and therefore not lawful. But this is equitable. So what we might see here is some cases where some damages are still applicable, but it's up to the court to decide. So the court might decide, for example, that they will give damages, or an injunction where an injunction might be sought, so they give damages instead. So Miller and Jackson, you probably come across this case when doing negligence, for example, but the claimant's use of their garden was disrupted by cricket balls being hit into it from the adjoining recreation ground. Now the cricket club tried to compromise with the claimants by erecting high fencing and instructing batsmen to hit the ball on the ground. However, the claimants continued with their action to stop cricket being played. Now the court weighed up the use of the ground and the benefit of the sport to the community against the claimant's use of their garden. So they decided the community use of the ground outweighed private use and refused an injunction. So this idea might also be applicable to playgrounds and football fields, rugby fields and so on also. In Adams and Ursel, a well-used fish and chip shop was causing a nuisance to a local residents due to smells coming from it, and it was forced to close. But today, it's probably likely that this wouldn't happen. The court would make a positive order, such as extractors. So the court would accept as a nuisance, but it would not force them to close. So Dennis and the Ministry of Defence is a really good example of an equitable remedy for this kind of scenario. The court here considered the benefit to the public should be a reason to award the compensation to the claimants rather than an injunction to stop. Now the claimants here brought action because the fighter jets constantly flying low over their property. Now the Ministry of Defence defended this on the basis that the training of pilots was for the benefit of the public and of the country. So the court awarded substantial compensation but didn't limit flying. In Coventry and Lawrence in 2014, comments were made by one of the judges that an injunction should not be automatically be ordered in a nuisance case, so there's a shift towards damages instead. Many court claimants will take court action as a last resort to stop nuisance continuing and won't be looking for compensation, but in light of this decision, it cannot be guaranteed for a successful applicant, so even if they win the case, even if it is nuisance, the court may be reluctant to award an injunction and may look to award compensation instead. So we looked at quite a number of factors here. So we looked at all the different factors. We need a balance though. So it's important to note that the court will be looking at a number of factors in each case. Now they do attempt to draw a balance, but But if one factor is particularly important, then this may be enough to decide the case. So when applying the law, it isn't necessary to apply all factors, so we don't need to go through all 6 of those factors and consider. Just select the ones which you think apply those, and then make a balanced decision at the end of any application. So we completed the outline of the main features of a claim. So who's the claimant, who is the defendant, what is interference, and is the interference unlawful? But now we need to consider, are there any defences? So the 3 main defences you may come across and may use within a nuisance claim are prescription, statutory authority, and act of God. So prescription is a defence unique to private nuisance. In essence, it means if an action's been carrying on for 20 years and there's been no complaint, then the defendant may be said to have a prescriptive right to continue, so they're allowed to continue. Now we do need to consider the following cases: Sturgis and Bridgman, and Coventry and Lawrence. In Sturgis and Bridgman, the vibrations from a defendant's machinery disturbed the claimant, who had bought land next door and was using it as a doctor's consulting room. Now, the claim was based on, or the defence was based on, the noise had been going on for 20 years. But the defence of prescription actually failed, because since the court held the nuisance only began when the consulting room was built, so it's from that's when the clock started on the nuisance, so it hadn't been 20 years from that moment. Now the activity must have been a nuisance to the actual claimant for at least 20 years, and they'd never sort of made an action against it or a complaint against it. The fact that it may have been a nuisance to people occupying other property is not sufficient to claim a prescriptive right. So in Coventry and Lawrence, the claimant bought a house near the defendant's motorsport stadium, and planning permission had originally been granted in 1975 for speedway use and subsequently for other motorsports. Now the claimant brought an action based on the noise nuisance, requiring an injunction limiting the use of the track. The Supreme Court confirmed the existence and granted this injunction. They did suggest, however, that damages may be considered as a remedy more often in nuisance cases, especially where planning permission had been awarded to the defendant for his use, for the use of his or her land, or where public interest is involved, such as employees losing their jobs if an injunction is awarded. So in deciding this, they did sort of say this may not be the case in the future. Now, one thing that can undermine prescription is the notion of moving to the nuisance. So if the claimant has come to the nuisance and it wasn't an issue previously, then the defendant may have a defence. So in Miller and Jackson, for example, the claimant bought a newly built house next to a cricket ground where cricket had been played for 70 years and suffered damage as a result of balls being hit into his garden. It was decided that there was a nuisance and no prescriptive right, because the period only started when the houses were built. So similar to Sturgis and Bridgman, in that they undermine a defence of prescription. Now we have statutory authority also. So this means if an Act of Parliament exists or planning permission exists, for example, from a local council or local authority, then if that activity is regulated or licensed by environmental or other laws, then statutory authority can be an effective defence. So if we look for the case of Allen and Gulf Oil Refining, Gulf Oil had obtained its own private Act of Parliament to authorise its expansion in Milford Haven in South Wales. Now the Act provided specifically for the acquisition of all necessary land and the construction of a refinery, but no express provision was made by the use of and operation of the refinery once it had been built. Now local residents complained about the noise and vibrations emitted by the refinery. The House of Lords took the question to be one of statutory construction, i.e. was a nuisance authorised by the statute expressly or implicitly, in which case was the defendant would not be liable. They held by majority of 4-1 that the operation of the refinery was authorised implicitly by the Act. And Lord Diplock pointed out that Parliament can hardly be supposed to have intended the refinery to be nothing more than a visual adornment to the landscape in an area of natural beauty. Clearly the intention of Parliament was that the refinery was to be operated as such, so as a refinery. So sometimes they will have implied statutory permission. Another example is Marchit and Thames Water. The claimant's land here was repeatedly flooded over several years with sewage as a result of the defendant's failure to control it. The cause of the problem was that in the time before the sewers had been laid, many years before, many more properties had been built and the sewers were no longer sufficient to do the job. The defendants, who were aware of the problem, have failed to address it. So Mr. Marchich sued in nuisance and also claimed to be a breach of Article 8 of the European Convention on Human Rights. The Court of Appeal upheld Mr. March's claim in nuisance, but also held that the trial judge had been right to find out the case under the human rights should not succeed. In Gillingham Borough Council and Medway Dock, local authority planning permission can act, was supposed to act in the same way as justification. So planning permission was granted to use part of a dockyard as a commercial port. Now access was only available by residential roads, which caused residents noise disturbance from heavy lorries, for example. The court decided that as the character of the neighbourhood had been changed by the planning permission, what could now previously have been a nuisance could now be considered reasonable. So we've gone from a sort of quiet area to an industrial area. That's the changing of the neighbourhood. It was not held to be an actionable nuisance because of the granting of the planning permission, changing the character of the neighbourhood. And in Wheeler and Saunders, so that if planning permission doesn't change the character of the neighbourhood, it won't operate as a defence. So in Wheeler and Saunders, a pig farmer was granted planning permission to expand by building 2 more pig houses, each containing 400 pigs. One pig house was only 11 metres from the cottage of the neighbour, who then took action in nuisance due to the strong smells he experienced. And the Court of Appeal confirmed that the grant of the planning permission could only be a defence if its effect was to change the character of the neighbourhood, and so that the nuisance was not unreasonable. But this had not been the case here, and the planning permission was not a defence because, in essence, the neighbourhood remained the same. It had a farm next to it, didn't change anything, even though there were more animals. So the defendants could not use this as a defence. So one other defence is an act of God. Now this is an event which happens independently of any human action. For example, a storm. It could be a thunderstorm. It's got to be an unforeseeable weather event. Now this is a complete defence as outlined in Nichols and Marsland. This was a storm in this case. And if an occupier becomes aware of the nuisance and fails to remedy it in a reasonable time, they may be liable for any damages subsequently it causes. So now we looked at defences, we need to look at remedies as well. So what are the possible outcomes? We've already mentioned 2 already, so throughout this presentation, this video, we've looked at injunctions and compensation, and the idea that we're more likely from after Coventry and Lawrence to actually obtain damages as opposed to an injunction. So the injunction, if possible, could be a positive injunction or a negative injunction. So a positive injunction will be making somebody do something. So for example, if it was smells coming from a chip shop, they could give a positive injunction, which means that they would have to install extractor fans and so on, for example. But then a negative would be to stop or to prohibit some behaviour. Now the injunction could be linked to the awarding of damages where losses has occurred as well. So remember, it is tort law, there might be consequential losses which also may be needed to be claimed for. The Court of Appeal in Coventry and Lawrence laid down the guidance as to remedies and nuisance. They said an injunction could be the default order in a nuisance claim, but it's open to the defendants to argue that an award of damages would be a suitable alternative, and an injunction will not automatically be granted. Now, one of the judges suggested damages would ordinarily be an appropriate remedy in nuisance, and of course we might see a shift towards this, so you should make some comment on that in your answers. And one further remedy which is particular to a nuisance claim is the remedy of abatement. So abatement is where you would, for example, enter the defendant's premises in order to prevent further nuisance. So this could be as simple as chopping down overhanging tree branches, but could be as positive as blocking a waterway off or something. So it could be anything, going onto the defendant's premises to be able to fix the problem yourself. So we've covered the key features then of a private nuisance claim. So who is the claimant, who is the defendant, what an interference is, whether that interference is unreasonable or unlawful, looked at potential defences, and indeed outlined particular remedies for this particular type of tort as well. And so one final issue to discuss is the relationship between nuisance and fault. So nuisance isn't a fault-based tort in the same way as negligence, in which we have to prove a duty of care which has been breached and then there's causation as a result of breach causing harm. There is clear fault in negligence claims. This one we need to establish some fault. So for example, unlawful interference and some element of fault in one of those factors is possibly how we do it. For example, malice is clearly doing something wrong on purpose. So we do have some element of fault, but it's not truly a fault-based tort. And the courts have encouraged parties in civil cases to use ADR, and it's no different for this either. So try to come up with some common ground before moving to civil litigation through the courts. So that's all for this video. This explains the theory and some key cases behind the concept of private nuisance. There is a separate video which is going to take you through how to apply the law, so you can watch that one next if you need to. Thanks for watching.